Nnamdi Kanu, the leader of the indigenous people of Biafra, has expressed surprise that a high court selectively implemented a Supreme Court judgment favoring only parts against him. He criticized the court for not applying the judgment holistically. Nnamdi Kanu maintains his innocence and states that there are no valid charges against him. He argues that no trial can take place if key sections of the Constitution and a Supreme Court judgment are violated. Nnamdi Kanu further highlighted that he has been in solitary confinement for 4 years. He dismisses the possibility of the case being reassigned to a lower court and criticized journalists and legal correspondents for not thoroughly studying court ruling and judgments. He urges journalists to do basic research to understand the emptiness of the charges against him. He points out that the charges against him have been repeatedly altered. Nnamdi Kanu mentions that he allegedly committed a crime in England by making a broadcast from London. He claims that Nigerian courts do not have jurisdiction over him since the crime was allegedly committed in England. Nnamdi Kanu asserts that only a UK court can grant Nigerian courts the authority to try him. He explains that after this argument, the prosecution amended the charge to remove the London location. The amended charges are allegedly contrary to Nigeria's Terrorism Prevention Act of 2022. Nnamdi Kanu accuses the prosecution of violating their own laws in handling his case. He argues that it is impossible for him to stand trial under such circumstances. He also asserts that the entire legal process against him is being mismanaged. He emphasizes that Nigerian courts lack the jurisdiction to try him for actions that occurred outside Nigeria. He accuses the court of cherry-picking elements of the case to support the prosecution stance, and further maintains that the charges against him are virtuous and lack substance. Nnamdi Kanu, the leader of the indigenous people of Biafra (IPOB), addresses his legal situation, primarily focusing on the judicial complexities surrounding his trial in Nigeria. Nnamdi Kanu has been embroiled in a contentious legal battle with the Nigerian government, facing charges relating to terrorism and separatism. However, he maintains argument as presented in the video, which revolves around the idea that no Nigerian court has the jurisdiction to try him for a crime he claims was committed outside Nigeria, specifically in London. Nnamdi Kanu claims that no Nigerian court has the jurisdiction to try him stems from the fact that the alleged offense occurred outside Nigeria, specifically in the United Kingdom. He argues that under Nigerian law, offenses committed outside the country cannot be tried in Nigerian court unless certain conditions are met, such as collaboration with foreign courts or treaties that allow for such jurisdiction. In his case, Nnamdi Kanu insists that the Nigerian courts have failed to follow the necessary legal protocols, thereby rendering any trial unlawful. From a critic point of view, this argument raises important questions about extraterritorial jurisdiction. Under international law, countries can sometimes prosecute crimes committed abroad, particularly in cases involving terrorism or transnational offenses. However, these situations require clear legal frameworks, such as mutual legal assistance treaties or agreement between nations. In the absence of such agreement, Nnamdi Kanu's assertion that no Nigerian court can try him may have legal merit. Yet, this also opens up another dimension of the discussion. If the Nigerian government is indeed trying to prosecute Nnamdi Kanu without adhering to these legal frameworks, it raises concerns about the rule of law and judicial overreach. Is the government manipulating the legal system to achieve political ends? Critics might argue that the Nigerian government is using the judiciary as a tool for political prosecution, especially given the sensitive nature of Nnamdi Kanu's separatist movement, which calls for secession of the southeastern region of Nigeria. A recurring theme in Nnamdi Kanu's statement is the selective implementation of court judgments. He expresses frustration that the Nigerian courts are cherry-picking parts of rulings that are unfavorable to him, while ignoring the aspects that could potentially exonerate him. Specifically, Nnamdi Kanu refers to a Supreme Court judgment that he believes should have been implemented holistically, not selectively. From a legal perspective, this criticism touches on the broader issue of judicial impartiality. The judiciary is meant to be an independent arm of government, free from political influence. However, in many countries, including Nigeria, there are often concerns about judicial independence, particularly in high-profile cases with political implications. If the courts are indeed selectively implementing rulings to serve the interests of the states, it undermines public trust in the judiciary and threatens the integrity of the legal system. Critics could also interpret Nnamdi Kanu's frustration as part of a larger narrative of state repression. His comments about journalists and legal correspondents failing to understand the rulings suggest that there may be a lack of transparency in how the judiciary operates in Nigeria. Nnamdi Kanu implies that the legal system is opaque and that key rulings are not being scrutinized or properly understood by the public. This raises important questions about judicial accountability and the role of the media in holding the judiciary to account. Nnamdi Kanu's criticism of the media for not adequately researching and understanding the legal complexities of his case reflects a broader issue regarding the role of the press in shaping public opinion. He argues that journalists are not doing enough to explain the intricacies of the legal system, thereby allowing the government to manipulate the narrative surrounding his trial. This critic points to a fundamental issue in Nigerian journalism, the lack of in-depth legal reporting. A well-informed media plays a crucial role in democratic societies by providing the public with the information they need to hold the government accountable. In Nnamdi Kanu's case, his accusation that the media has failed to do its due diligence highlights the challenges that journalists face in covering complex legal issues. Reporters may lack the resources or expertise to fully analyze court rulings, which can lead to superficial coverage of critical issues. This creates a feedback loop if the media does not provide the public with accurate or in-depth information. Public opinion can be easily swayed by the government's narrative. In Nnamdi Kanu's case, this could mean that the public is not fully aware of the legal nuances of his trial, leading to a skewed understanding of his situation. Critics might argue that this lack of critical media coverage allows the state to continue its selective application of the law without facing significant backlash from the public. One of the most striking aspects of Nnamdi Kanu's situation is his prolonged detention, including 4 years in solitary confinement. From a human rights perspective, this raises serious concerns. Solitary confinement, particularly for extended periods, has been widely criticized by international human rights organizations as a form of torture or cruel, inhuman, and degrading treatment. Critics of the Nigerian government might argue that Nnamdi Kanu's detention is not only unlawful but also a violation of his fundamental human rights. Furthermore, Nnamdi Kanu's statement that the 5th year will not kill him speaks to the psychological toll that such prolonged isolation can have on an individual. Human rights organizations have long documented the devastating mental health effects of solitary confinement, including anxiety, depression, and even psychosis. Nnamdi Kanu continued detention without trial also raises questions about due processes and the Nigerian government's commitment to upholding the rule of law. From a legal standpoint, Nnamdi Kanu's detention without trial could be seen as a violation of his right to a fair trial under both Nigerian and international law. Article 7 of the African Charter on Human and People's Rights, to which Nigeria is a signatory, guarantees the right to a fair trial, while Section 36 of the Nigerian Constitution provides similar protections. If Nnamdi Kanu has been held without a fair trial for 4 years, this will represent a significant breach of his legal and constitutional rights. Given the complexity of Nnamdi Kanu's case, public reaction has been divided. Supporters of the Nigerian government might argue that Nnamdi Kanu poses a threat to national security and that his detention is justified. However, critics of the government have raised concerns about the selective application of the law, judicial independence, and human rights violation. The broader implication of Nnamdi Kanu's case also speaks to the need for judicial reform in Nigeria. The selective implication of court ruling, prolonged detention without trial, and the lack of judicial independence all point to systemic issues within the Nigerian legal system. If Nnamdi Kanu's case is to be resolved in a way that upholds the rule of law, it will require a commitment to transparency, accountability, and the protection of human rights. In conclusion, Nnamdi Kanu's legal battle raises significant questions about jurisdiction, judicial independence, and human rights, and the role of the media. His arguments highlight the complexities of the Nigerian legal system and the challenges that come with prosecuting high-profile cases with political implications. What do you think? Should the Nigerian court be allowed to try Nnamdi Kanu, or does he have a valid point about jurisdiction? How can the media improve its coverage of complex legal issues like this? I will play the video for you guys to watch and see for yourself. Feel free to share your thoughts, opinion, and comments. Don't forget to like, share, subscribe, and turn on notification icon to be notified whenever I drop new updates.
So I was actually surprised that a high court have refused to obey or abide by the determination of a Supreme Court judgment.
And then take the only part that is against him and then refuse to apply the part that is in favor of him.
This cherry picking of what was contained in the Supreme Court judgment is what I'm against.
Yes, that's correct.
It should be implemented holistically.
Yes.
I'm not against facing any trial.
judgment.
After all, I'm innocent. They have not been against me. But there cannot be any trial when key sections of the Constitution and a key Supreme Court judgment has been violated by a court of law.
So you'll be patient for the case to go back and come back to court?
This is my 4th year in solitary confinement in detention. The 5th year will not kill me.
Sorry, what if the case is also reassigned back to her? Will you still be comfortable?
It's not going to happen.
No, it won't happen.
It won't happen. It doesn't happen.
It doesn't happen that way. It doesn't happen that way at all.
Thank you very much.
These are the things that the public must understand. Most of you journalists, the legal correspondents, you don't take time to actually study some of these rulings and judgments. Go and study. In fact, I'll give you.
Bring that envelope. Bring the envelope.
Look at it here. Look at it here. Look at it.
I'll give it to her because I think she's a bit more.
Give her the shoulder judgment.
Can you hold this for me?
She can.
I want to let the whole world understand something. Very, very clear. In all this is judgment of the Supreme Court. It made it very clear that even that the impartiality of the judge is questionable. And is here. Where is it? Please do bear with me. It says it here.
I like
what is
it.
Page? What is that again?
Where
it says
page 18.
all these things are online. Is it not page 18? All these things are online. So I suggest that the journalists in this country actually take out time to do some basic research. It's not difficult, just minor research. You will understand the vacuousness, the emptiness of all the charges against me.
Okay.
They kept switching the charges. They said I committed this crime in England, isn't it?
Yes.
I made a broadcast in England.
Yes.
And in 9 charges leveled against me, this place where I committed this crime was London, in the United Kingdom.
Yes.
When my lawyers came to see me, I had a discussion with them about how I'm going to defend myself. I told them that no court in Nigeria has jurisdiction to try me. Because since this offense was committed in England, so they said, it's only a UK court that can give a Nigerian court the authority to proceed, isn't it?
Yes.
Based on that, they now amended the charge again and removed London.
Location of the broadcast.
Location of the broadcast. Contrary to section 196,
174 of the Terrorism Prevention Act 2022.
in violation of their own laws. Violation of their own laws. And you want me to stand trial under such circumstances? Is that possible? Nnamdi Kanu to stand trial where all these shenanigans are going on? It's not possible.